this Thursday, it's now time for the big story, and as we have done this entire week, we're focusing on the events at the Supreme Court where the hearing of the petitions seeking to invalidate President Uhuru Kenyatta's win in the October repeat presidential poll have concluded. Kenyatta's lawyers and Attorney General Professor Githu Muigai have dismissed the withdrawal of NASA flag bearer Raila Odinga from the presidential race as inconsequential. Led by Fred Ngatia and Ahmed Nasser Abdullahi, the lawyers explained that the Constitution does not provide for fresh nominations in a repeat presidential election. They also questioned the motive of the petitions, stating that the petitioners did not participate in the elections as candidates. Supreme Court judges are now expected to go into sequestration to deliver their ruling next week on Monday. On the show tonight, we will be speaking to two legal minds. Felix Owor is going to be joining us shortly. He's an election law expert. Dr. Duncan Ojwang is the Dean of the School of Law at the Nazarene University Law School. We'll have that conversation with them, but we will also be speaking to Sophia Wanuna, who is our lead reporter and has been following these proceedings up until today, the last day. Sophia, good evening. So here we are, finally. All submissions done. Talk to us about what took place in court today.
Good evening, Yvonne. Today was day 2 and the final day of the hearings in the presidential election petition. And today, Uhuru Kenyatta's lawyer, President Uhuru Kenyatta's got to submit in court. We heard from Fred Ngatia, senior counsel, Ahmed Nasser Abdullahi, and other of the lawyers, as well as the two interested parties. That's Attorney General Githu Muigai, as well as counsel for Ekuru Okot. Let's begin with some of what we heard. And from senior counsel Ngatia, he said and submitted that when the Supreme Court in their 1st of September judgment, in essence, nullified or vitiated the results of the presidential election on the 8th of August, that they did not nullify the process or void the entire electoral process as to warrant 4 nominations. Because remember, that is at the heart of the petition by Harun Mwau, that there should have been nominations conducted before the repeat presidential election. He went further to say that Justice Mativo of the High Court, his decision on the Ekuru Okot case was vital, was crucial, in the sense that on one hand, yes, it allowed for the other candidates to participate in that repeat election, but also that the judge, in reading out the judgment, and even when you look at the details and the explanation, is that he found there was no time sufficient, at least, to conduct nominations in that repeat election. However, we know these are claims that have been were rebutted even this afternoon, before even in submissions by the petitioners. They had indicated that according to them, there was time. If IEBC had stuck and conducted itself in accordance to the rule of law, they would have been able to conduct the nominations before this particular repeat election. Ngatia going further to, in essence, agree with that obiter dictum of, you like, the advisory of the Raila 2013 decision, where then the Supreme Court had guided, and when questions were raised as to how certain situations would play out if they arose, that the boycott, or rather the leaving of the race, the presidential race, abandoning, that's the word I'm looking for, by Raila Odinga, would have in essence forced there to be nominations, and the process began. But he says because of the Justice Mativo decision that came a day after Raila Odinga abandoned the race, then the field changed. Then there were submissions by senior counsel Ahmed Nasser Abdullahi, and Yvonne, his was one submission geared at least on one particular area, and it was to question the petitioners. And he talked about Article 114, talking about a person can't file a presidential petition, that there needs to be clarity of what a person is, saying that a tourist from the United States could be in Kenya and decide they are a person, they can file, but went on further to break down and even go to the specifics of the individuals before the court, the petitioners, that is, on Harun Mwau dismissing his petition and saying that he's a fascinated layman who did not even vote, at least according to their affidavits and all the information availed to the court. They did not participate in this election. So on that basis, they should not have been allowed to then question or raise a dispute in a process they did not participate in. And also he raised off Halef Khalifa and John Jamwe, who are the other two petitioners, calling them the high priest of civil society, and that their petition should be seen as a proposal for funding, donor funding is how he described it. So saying that at the end of the day, these individuals are not rightfully before court just by virtue of the fact that, Yvonne, they did not participate, they did not vote in the repeat poll. And of course, Attorney General as well in his submission saying if this petition is successful, then what the court will be doing is rewarding individuals who want to sabotage the Constitution. So those are some of the submissions we were able to hear today, as alongside a Kuru Court's lawyer, who also asked that these two petitions be dismissed. Yvonne.
Yes, so we now know that everyone has had their day in court. All the submissions have been made by all litigants. Talk to us about the timeline. We do know that we expect a ruling and a final verdict on Monday. But so where do we go from here?
So the judges from adjourning this evening earlier have now retreated, and they will be have conferencing around what they've been able to hear, going through the numerous material as well they have with them in this petition. Because remember, other than what we heard in court today, that's not even a drop in the ocean as far as the kind of material they're able to canvass, or rather they will have to go through in reaching a decision. So that will happen in the next few days. At least the Chief Justice did announce they will be making and rendering their judgment on 20th, and 20th is that last day by which they must in fact deliver their judgment on that 14-day timeline. But also remember that Saturday, that even much now they have Friday, Saturday, Sunday. Saturday for the CJ, because of his religious leaning, he will perhaps not be participating in any further engagement, at least for the time that he's observing Sabbath. However, I believe they will be able to work around a way in which they still are able to meet the deadline of the 20th. But also important to mention, Yvonne, on the submissions today, remember there was that scrutiny exercise that the other counsel, Ndubi, had sought on behalf of John Jamoe and Halef Khalifa. So he was not able to file a report today. What, however, he was allowed to do is make mention of what he was able to observe in the access exercise that was granted to him. Yvonne.
Yes, so after a decision is made on Monday, could you give us either scenario if they choose to uphold the re-election of President Uhuru Kenyatta, or if they nullify that process again? What sort of timelines are we looking at?
So if they choose to dismiss both petitions, in that they find President Uhuru Kenyatta was validly re-elected, 7 days after that, which will be on the 27th of this month, President Uhuru Kenyatta will be sworn in. However, if they decide to uphold the petitions, then depending on what directions they give, but it should be back to the ballot in 60 days, just like we had between the 8th of August and the 26th repeat election. Yvonne.
Oh, yeah. One last thing. I know you were talking about the proceedings today in court, but there was also some drama. There was legal exchange between the Attorney General and Harun Mwau's lawyer. Tell us more about that.
Yes, Yvonne, it is a moment that stood out. A lot of people talking about it on social media. While Attorney General, who was an interested party, was making his submissions, counsel for Harun, or rather, for Harun Mwau, that counsel Musyoka took to the, stood up, and the CJ recognized that and allowed for him to speak. And he took objection with the submissions that were being made by the Attorney General, saying that the Attorney General was going beyond the scope of what, according to him, he had been allowed to submit on. So saying that the Attorney General, in fact, was acting, he said, as counsel, or behaving or submitting as if he was counsel for IEBC and the IEBC chair. So after he took his seat, the Attorney General explaining that he, in fact, did have the leeway and to be able to talk about all of these other matters and submit on them, then to run further with a jab there against the attorney, saying that there is a consideration to come up with legislation that caps the number of years one has practiced before they can be allowed to practice at the Supreme Court of Kenya. And he went further to say, ladies and gentlemen, this right here is an example of why we would need that kind of legislation. Towards the end of the submissions, when counsel for Mwau were doing the rebuttals, at the end, the counsel who then those remarks were directed at took objection with it, telling the CJ he did not appreciate those remarks coming from the Attorney General, that in fact he has practiced since 1998. So he's been there, he's been around the streets, courtroom streets, if you like, and that comment he was offended by and did not take it lightly. Yvonne.
Yeah, so some interesting drama. Thanks for that, Sophia Wanuna, as we look forward to that decision that will be made on Monday. Thank you. Sophia Wanuna has been covering the Supreme Court petition round 2 and indeed round 1 as well. So just giving us a summary of what to expect. But just to buttress what Sophia has been telling us, let's listen to what the various litigants have had to say today at the Supreme Court.
My submission before this Honorable Court this morning touches on a single issue, which is that there isn't a valid petition before this court, and the 3 petitioners herein, namely Honorable John Harun Mau, Njonjo Mwe, Khalif Khalifa, lacks the constitutional locus standi to institute a petition under Article 140, challenging the election of Honorable Uhuru Kenyatta, the 3rd respondent herein, as President of the Republic of Kenya. My Lord, it's my submission that from the pleadings of the petitioners, it is quite clear that they have not participated in the election of 26 October. And I will show you that they do not, or they are not a person under Article 140 of the Constitution. They are not that person Article 140 refers to. My Lords, it's my submission that a person who under Article 140 of the Constitution files a petition challenging the election of a candidate must not do that as an academic exercise or as a game of chance or as a proposal for donor funding or become a national irritant. That person who files a petition under 140 must have a genuine grievance.
The petition before this court is about the 26th of October election. It is not the previous election that was held on 8th of October, because we are likely to drag the issues of the previous petition into this petition. The court should look at IBC and ask itself, after we gave our order of 21st, or rather 1st of September 2017, what was complied with? And when you look at the affidavit sworn by Dr. Ekuru Aukot, he has annexed a comprehensive report indicating the failures that were identified as a result of this court's judgment, the law that is applicable, and the mitigating measures that were put in place to ensure that we have sealed those loopholes. I urge this court to look at those, that affidavit and compare that with the submissions made by my learned friends here, and it will find, rather arrive at one conclusion, that IBC conducted this election in a manner that is in compliance with the laws and the Constitution of our country.
As at the date we left this court after your judgment, there was no doubt at all what the fresh election entailed. And I think that the chairman of IEBC has been so unfairly, in my view, criticized in how he organized the election, because he was following to the letter the ruling jurisprudence of the day, which was the decision of the Supreme Court. Life would have been easier for him had the intervention of Dr. Ekuru Okot not been made. That intervention, which resulted in the judgment of Mativo J, then created a new dynamic, not necessarily a tension at all between the Supreme Court advisory opinion, as I understand it, and Mativo J's decision. The two could be read harmoniously as passively interpreting the Constitution, which is what the chairman of IEBC did. In my very, very humble view, therefore, my lords, the one issue that this court needs to appreciate is that the election of the 26th of October was conducted under the supervision of the court, because we conducted that election under the order of the court. And the order of the court is so clear.
All right, so those are the events that took place in the courts today. Let's have our discussion now. Dr. Duncan Ojwang with me. He's the Dean, Nazarene University Law School. Dr. thank you for being with us.
Thank you, brother.
So the case is done. Yes. What have been the highlights for you in this second presidential petition?
I think it has not been as glamorous as we expected.
Or as the first one.
Yes, compared to the first one, or with what is at stake. I think it has run a little more smoother. It has not been as adversarial. It has a mixture of younger and a little bit more senior counsel than the other one. You know, if you are watching Supreme Court ruling and you find yourself yawning like I was, then you realize that it wasn't as hot as we expected it could be. Yeah, even compared to O.J. Simpson trial. You know, it was something for
Does
everybody.
anything top the O.J. Simpson trial in the world at this point? Yeah. Perhaps, you know, putting a lot of premium on this one. But, and it's interesting that you mentioned, you know, the mix of litigants in that one. And, you know, we even saw a bit of, I mean, I think that was the sort of bit of drama, and we'll get to just, you know, some of the substantive arguments that were made in just a moment. But, you know, there was a bit of flair in that. I mean, this time the Attorney General was now listed as an interested party because, you know, not as a friend of the court, because some of his submissions were said to be, you know, leaning to one side. So what are your thoughts as to the performance of the lawyers and the Attorney General himself?
I think the Attorney General was wanted to be both, and the court said no, just be an interested party and bring your submission. Brought very strong submission. I think the performance of the lawyers, because it was less tense, because there was the milieu was not as dramatic as the other one. The lawyers were able to have an ample time.
Do you think there was more substance than flair this time around?
This time, the issues were fewer.
Yes.
They were less divisive. And so on issue, there wasn't much. But in terms of presentation, you could tell that the court I think it was a learning experience for everybody because you could tell the court is a little much more experienced, more calm, more in control.
Including the fact that the judges this time are very clear as to some of the issues that they wanted for determination. And they knew the amount of time they have to go back into once the hearings are done and make a decision. They didn't allow as much. In fact, they whittled down Njonjo Mwe's issues from 20 to 2. You know, they disallowed, what, 2 voters, you know, who wanted to come in. But it was just, they were very clear this time about what the issues were before them. Could that have been a learning lesson from the other one?
Yeah, from experience, from doing it, they were able to clearly see the trees in the forest and go for it. And even their line of question to councils, you could see they are very clear. They are looking at those issues. And so once they are very clear on the issues from the word go, you could see that it made their work very easy. Their body language a little more relaxed. And so I think there is maturity. Yes.
Perhaps the retreat that they had before might have helped. We will wait and see, though, once we've got the final verdict on Monday. So let's talk about, you know, a bit of the substance. So at the heart of this, and indeed the other petition, is really about the electoral process. What does it say about a country and its democracy if the electoral process is subjected to a judicial process twice in, what, 2 months?
Yes.
What are your thoughts about that? Like, where do you think this is headed, that we're now deciding our electoral democracy within the judiciary?
No, it could be maturity, but it could also be a bad thing that whoever has the best lawyer get to maybe almost win the election. Election are competition, and so we have to wonder whether this is an extension of that competition through legal process. But you know that the Constitution really opened up that the judiciary is supposed to even be the one guarding our values, both those principles and in the Constitution, democratic space, good governance, accountability, inclusivity, and so courts have been invited, because remember, this is a court operating under the 2010 Constitution that is telling us that the court also get their authority from the people. Just like the president gets authority from the people, the legislature gets the authority from the people. These are not courts that are merely appointed. According to the Constitution, they also sit there on behalf of the people. Yes.
So you see it as the Constitution flexing its muscle and us going through the rigors of the laws that we put in place?
Yeah, we are in constitutional democracy. And I think that courts and law, being that court are the final determinant of what is constitutional and what is legal, have a bigger role. But at the same time, even the way they are interpreting, you know, they have said that the Constitution cannot be interpreted like a journal. It is purposive, holistic, values, our history, our context. So, but you'll rather have 6 experts tackling this and having stress over this than us resolving it in the street. And so at whatever cost, you can see that we will rather have them having the stress and having all the...
the alternative is one we don't want to find. Okay, interesting. Dr. Duncan Ojwang is the Dean at the Nazarene University Law School, still here with me. Please stay with me, sir. We're taking a small commercial break here on The Big Story. When we return, more analysis. Felix Owor will also be joining the panel. We'll be right back.